All right, ladies and gentlemen. Well, we have people still trickling in. I want to welcome everybody here today on this beautiful Wednesday to our second in a series of ongoing webinars that we are doing on a quarterly basis. This one entitled Cybersquatting and Trademark Infringement in the Global Domain Sector. As many of you know, and I see a lot of familiar faces on the attendee list. 101 Domain is a global domain name registrar. We have arguably more accreditations than any other registrar out there in all new GTLDs, legacy generics, and pretty much every country code you can imagine. And as you can also imagine with that, navigating the landscape in terms of trademark infringement and brand protection when it comes to domain names can become a little bit overwhelming and a little bit complicated. So this particular webinar today is designed to give you some insights on that and give you an overview of how the global domain system works in this aspect. Just want to point your attention to your GoToMeeting functionality. We have included a couple handouts that you're able to download during or after the webinar, and we do have a person moderating the chat channel, so if you have any questions that come up during the webinar, we will have a Q&A at the end, so hopefully we can get to all those questions in time. And with that, thank you all for attending, and I'm going to hand it over to Kimberly, who's our Senior Corporate Services Executive, and she's going to take it from here.
Thank you, Anthony. Welcome to everyone. And I'm Kimberly Darwin, the Senior Corporate Services Executive at 101 Domain, and that means I work with the corporations, a lot of law firms, and helping you maintain your brand on the internet. So what we're going to talk about today is with 101 Domain, we'll always have something centered around a domain name or enabling you to better use domain names. So this webinar will also discuss that. And because they are such a significant part of brand visibility, we really do want you to be educated on how they're being used, both by your client and other people who may not really have the right to use them. So with that said, we will start by talking about who owns domain names. So besides you or your client owning domain names, there are other people who have interest in owning them, and the two major groups are the domain investors and the cyber squatters. So domain investors will generally be your speculators, those people who are watching what's coming up as far as trends are concerned, putting words together and then registering them in advance of that trend. And that's been going on since, let's see, when did I start? In the 90s, where people were saying, oh, that sounds like a good idea. I'm going to go get that domain name. So these people were doing it from a speculative basis, hoping that it would turn out to be profitable for them. And as you can see with insurance.com, that was the highest publicly recorded domain name sale at 35.6 million. So you can see that these names are paying off. Insurance.com would have been one of those that was registered way, way, way back by an investor. So the investors are pretty savvy for the most part. They understand the market. They understand the legal nuances and the trademark rights of owners, and a domain investor that's been around for any length of time is going to know to stay away from trademarked domains. And that is a little bit different from the flip side, the cyber squatters over here, who will knowingly purchase a domain with the intent to make profit like a domain investor does, but they do it for different reasons. So three of the reasons I've listed here, they divert traffic from the legitimate brand owner, meaning, and I'm going to have some examples on the next slide, meaning that they are intending to kind of piggyback off of someone's established brand and use those visitors who think they're visiting the actual brand for all sorts of things, like number 2, harvesting their sensitive information, like phishing, or selling them counterfeit items, which is in the case of fashion, makeup, even motorcycles and cars at this point. So those are the 2 main reasons that someone that would be called a cyber squatter, and that's in quotes, of course, would be purchasing a domain. But the majority of them really do purchase it to sell it back at a profit, thinking that they will keep the price of the domain name hopefully underneath the cost of a dispute and be able to make a profit on the name. And that backfires quite a bit. And as we get a little more savvy in this area, it's going to backfire for them more, hopefully. And when it comes to both investing and cyber squatting, the domain name extension does matter. So those generic top-level domains like .com and .net info, those that you're commonly used to seeing businesses associating their main sites with, those are governed by ICANN, so there's a dispute policy involved in that, and it's very structured. Now, when it comes to country code domains, it's a completely different world because they are not governed by ICANN, and each registry can have its own dispute process or none whatsoever. And so when your client's brand is being abused by a country code domain, you have a little bit of a different path to take in order to dispute their ownership. Okay. So we're going to go over a couple cyber squatting trends that are showing up right now. Typo squatting, that's been around a long time and it's still prevalent. I've put 3 examples up here. You can see Facebook.com, Goggle with 3 G's, Target with 2 T's. Very easy to pick up and very easy to abuse because, you know, I'm sure you've been in a hurry and you've typed into your address bar something, a misspelling, and that's what these typo squatters are banking on. So they'll set up a mirrored site that you're so busy you don't even realize that you're on. Another trend is combo squatting. I'm sure that you've probably seen this. If hopefully you're used to hovering over links in your email before you click on them. And when you see that in the lower left-hand corner where it's got unionbank-security.com, that's definitely something you would want to question. It's very easy to buy a domain with these hyphens in them, and they are not always caught by the brand's monitoring system. And so very easy to set up a phishing site with something like this. Okay, and also we've got homograph attacks, which are relatively new. And this is abuse of the characters in a domain name. So if you can see on the right-hand side, we have Amazon.com with 2 different A's. And you'll see one of them is the Latin A, one of them is the Cyrillic A, and you really can't tell. Even when you're hovering over those links in your email, it could be difficult for you to tell based on your computer's configuration, all sorts of things. So homograph attacks are pretty new now, and I have had quite a few of my clients ask me for a report of what are the possible homograph attacks that are available for my brand, and we can make you that report that is free of charge if you are interested in that. And it's pretty amazing. The last one I did had probably about 300 different permutations for that particular term. So there's quite a few. And with that said, just in case you don't know, there is a way to block those terms in a Donuts block, a DPML block. Donuts is the registry that has released 241 different extensions right now, which you can see on the right. They do include a block that you can purchase for your brand or your client's brand. And now they do include that homograph protection. So you don't even have to worry about registering those names. If you are interested in the block and it works for you, they're automatically covered. So something to think about there. And as far as disputes are concerned, the UDRP and the URS, we talked about that in the last webinar a little bit about how you can file these disputes for any registry that is governed by ICANN. You would have to prove the 3 points here, that the name was registered in bad faith, and that could be from information you glean from the WHOIS, by obvious use and the content listed on the site, and whether you've got history of that registrant registering names that have been in disputes before. So all of those things can help you determine that. And also to prove that there is no legitimate interest in using the trademark. So, for instance, A.R. Mani purchased his domain name, armani.com, and although it does conflict with kind of a popular brand, he has a right to the name. So you would have to prove that in your dispute, that this person does not have legitimate interest in that name. And finally, that the domain name is confusingly similar to the trademark, and that would be using those 3 examples from above: homographs, typo squatting, and combo squatting. So those things you would be needing to prove during your dispute with the UDRP, which would transfer the name to the brand owner, or URS, which would suspend the domain name so that no one can use it and it expires out naturally. And so when we get to country code disputes, it's a little bit different because they're not governed by ICANN. Now, some may choose to follow ICANN guidelines, which makes everybody's life easier when they do, but there are quite a few that are just, it's basically the Wild West out there, and you will have to adopt their process if you are interested in disputing a domain name ownership in that region. So for instance, China, they have a 2-year deadline, and this has come up a lot with people lately. When you're not monitoring your brand's name and then all of a sudden you have these reports of names that are very, very much in infringement of your brand, and they're over 2 years old. China doesn't allow you to dispute those anymore, other than using a civil suit. So Chinese trademarks also will override other trademarks outside. And so it's very easy to apply for a trademark, which we're going to see in the next slide. Someone did for Michael Jordan's name, and be awarded a trademark in China, which gives you the right to, in China, to own that name. So these are some of the challenges that you might encounter if you're disputing in China. With Brazil, we're doing one in Brazil now, and they have a similar dispute process to UDRP in that at least you can kind of recognize the process that's going to be followed, proving the same 3 things, documentation showing that you have legitimate interest in that brand, that sort of thing. And on the flip side, Russia has none. So no dispute process whatsoever, in which case you are obligated to use civil litigation if you are unable to purchase the name. My experience lately is that with Russian names, the sellers have been good about coming to a fair asking price for the name to avoid that civil litigation, but know that it can happen if you are working on a .ru name. And this brings us to Michael Jordan. This is a really fantastic example of a Chinese resident obtaining a trademark in his name in Chinese, and you can see that on the lower left-hand corner. And he didn't like that. So they were creating apparel and shoes and everything with that logo using his name without his permission. So he did go to court and he did win, and it did set a precedent for protecting his name and personal names in cases like this. So hopefully we'll see an upswing of positive outcomes related to this. And if you want to read about that, I'll make sure that that link is sent out so you can read more about that decision. Here's another one with Groupon. And there was an Australian company that formulated itself after the Groupon model in Australia, called themselves Scoopon, and then applied for a trademark in Australia for Groupon. And in Australia, if you have even an application for a trademark, you have a right to purchase the name related to it. So that's what Scoopon did. And there was a lot of back and forth as to the ownership of the name, who deserves the name, and apparently they are following through with a civil suit because they could not come up with some sort of agreement. So in summary, we're here to talk about domain investing versus cybersquatting, and basically putting on your radar the opportunity for you to find out who's using your or your client's brands on the internet. And should you have any kind of abuse issues, know that there almost always is a way, almost always, even if it includes civil litigation, to deal with these owners. And hopefully they're just domain investors. Hopefully everything works out okay where you can negotiate a price or the dispute is settled in advance. But if you do have any questions about that, make sure you do ask them in the questions area, and we will work on that, answering all of those. And as far as the DPML, we discussed that very briefly in the webinar. We are going to have another webinar on December 6th. It's going to be specifically about the DPML. So if you or your clients are interested in learning about how the brand can be protected across all of the Donuts extensions, we're going to have Matt Bamonte from Donuts on there with us for a question and answer session, very relaxed, and you'll be able to ask any specific questions of Donuts as to what's covered, whether it would be worth it for your client, retroactive registrations, which it does cover, meaning things that have already launched. You can even block those. So that should be an informative session. And so I am going to open it up to questions now. And if anybody has any questions, I think we have none just yet, but I see somebody typing.
Kimberly, I wanted to mention, this is Anthony, guys, on homograph attacks. This is, I just can't reiterate enough, this is a new trend that we're seeing. And it's very hard to detect for a user and for a brand owner, quite frankly. When you're talking about different character sets, you're getting into internationalized domain names, and you really have to look at the coding behind these to recognize them. I can tell you from experience, 101 Domain, we're very aggressive in protecting our name around the world. We have the term 101 Domain and 101 Domains and variations registered in a ton of jurisdictions. We have seen personally some homograph type registrations that we've had to deal with, and they pop up for us periodically. So I really do recommend, as Kimberly mentioned, we can run a report for you or for your client on these, so at least you get a sense of what's out there. If any of these names are currently registered, we can help you zero in on those and really just put it in front of the client or the decision makers in your organization, because it is a known threat. It is something that is happening. And I suspect it's going to be happening more and more as word kind of gets out on this particular tactic.
Well, thank you. I agree. And I've actually had people send me some of these homographs and I was completely confused. I'm thinking, what are you talking about? Until I ran it through, you know, we have a tool on our site that will pull out the language for you and also translate for you so that you can check what those Unicode numbers are and make sure that you're actually going to the right site. Now, it is a huge thing and it is very hard to miss. And so this actually brings us to a question: what are the preventative steps one can take to avoid cyber squatting? Well, basically you've got two lines of thought. The defensive registrations, where most of my clients have chosen to do that, where we'll create a gap report for you, which is free, and allow you to see who owns your names and who doesn't own your names. And if you can defensively scoop those up, it will be an easier path for you or your client by owning those names and just directing them to your main site. Other than that, monitoring does definitely help. If you have a brand that's very volatile, meaning that you've got a lot of counterfeiters, or you've got people who maybe a bank or a law firm, anywhere where sensitive information could be collected, then you very well might want to be involved in some kind of monitoring so that you can watch those. The DPML block, great idea. It works for many people depending on your sector. So we're always happy to consult with you if that is maybe an option that you might consider for your client. And we've got, is the homograph registrations, are they allowed for generic extensions and donut extensions only? They are allowed for almost everything, but and Anthony, you can correct me, but I'm almost positive that anybody that allows any other kind of alphabet outside of Latin, it would apply to them.
That's correct. And if you look at .com as an example, .com allows a few dozen different character sets to be registered as .com name. So the strings in front of the dot, of course. And really, most of the generic names do allow quite a few character sets, and quite a few, I would say probably the majority of country codes do as well. If you go to our website, there is a section on the site that gives you insight into the different language sets, and we can always provide you that information as well upon request. But it is a technical capability that most TLDs do allow.
Okay, thank you. We have a question. Hi, Rob. Nice to see you here. What is the current price point for paying for squatted domains versus filing action? That's really a good question, and it depends on where that dispute would be, but assuming that you're talking about a UDRP or URS, or even those countries that have been following that UDRP process, it's usually about $4,000 or less. And that, depending on whether you're charging billable hours or what that would be, but the legal expenses on top of the filing fee, I would say roughly 4,000. And I'm seeing this in Russia. They're really good about knowing what those thresholds are, and they are pretty good about staying within it and giving themselves enough profit and making the transaction easier if you do come to a buying price and go through with that transaction. And let's see, left me another question. What is the current ratio of UDRP versus URS with regard to clients choosing one or the other? That's a good question. I don't have the exact numbers, but I'll give you pretty close. It's about 92% UDRP to 8% URS. And I am under the impression that there are two reasons for that. The first reason is that a lot of people don't know about the URS as much. And the second reason is that you really have to have a very, very solid case in a URS. Really, really, really obvious trademark infringement, because it's such a quick decision by one panelist. So UDRP still is reigning, and I think we did have a slide in there where it said that, yeah, what, 80% of the UDRPs are going on the complainant side, meaning that they are being transferred to the brand owner. So that's good news. And let's see, True, your question is, purchasing someone else's branded domain name illegal? What if they have an affiliate program and you are using the domain to generate business for them while also generating affiliate income for yourself? I'm not a lawyer, and so I won't be answering on whether it's illegal or not, but I have seen cases where a brand owner has not understood that a domain name was purchased for use, maybe by a distributor. This happens a lot in the vitamin industry, and they're actually selling their product. They think that they're doing good by using that brand, but they still may be infringing, depending upon whether there is an agreement in place for them being able to use that brand in a domain name. So it is case-by-case basis on that one.
In that, Kimberly, I would say if it's a generic name or a name that's under UDRP, it's not a question of illegal or not. It's whether the trademark holder is able to use the UDRP process to get that name back. So it's the three tests, really. Does the user have rights to the name? Is it damaging the company that you're attempting to be an affiliate for? And those do get into gray areas. It's, I think we've seen business models in the past that have focused on this type of thing, and it's gone in either direction. Some companies have been willing to work with those users developing those sites. Others have had a pretty strong enforcement stance on them as well.
Okay. Yeah, and I've seen it on both sides. Some brands really do rope in all of those domain names, and some just allow them to continue on with the use if they feel like it's not infringing on their trademark. They're just trying to expand. So you would definitely have to look at each case on that one. And do we provide domain monitoring services for homograph registrations?
We do. In our monitoring service that we provide, it does accommodate for homographs, and we can send you more information on that after the webinar.
Okay, let's make sure I got every question here. How long does the dispute process typically take? I think that we're probably talking about, if we're talking about a UDRP or a URS, oh my. Let's see. It really depends on how responsive everybody is, but the one that we've been doing for Brazil with a country code is probably 3 to 4 weeks. We would hope that UDRPs would probably stay in the 2-week range, and URSs do seem to be much quicker since it's a faster decision. So if that's a service that you're providing for your client, make sure that you're setting that those expectations. Okay. Any more questions? Let's see.
I did want to go back, everyone. Sorry, Kimberly, to the IDN tool that you mentioned. If you guys go to our website, down to the footer, the bottom menu at the bottom of the homepage, you'll see under Resources and Tools a link titled IDN Conversion Tool. So that will allow you to put a name in there, and it'll spit out the result of what it is, whether it's just Latin characters or a different character set. So it's a good tool to have handy. There are other tools like that out there as well. And additionally, if you go to any domain extension product page on our website, you will see at the bottom of that product page the different language sets that are available to be registered for that specific TLE. So also a good resource for you to keep in mind.
Okay, I think we got one more question from Johan. So for a company to take back a domain name, do they have to have registered their trademark before the domain was registered? I love this question. Or is it possible to take it back if other criteria are fulfilled? 99%, and you can correct me, Anthony, if you've seen more than this, but 99% of the time, yes. I think I've seen one fluke where someone registered or was in the process, or it was literally days between when the domain was registered and when the trademark was awarded. However, for the most part, you would need to have that trademark already awarded, with few exceptions, Australia being one where you're allowed to have an application, but that's a rarity. You would have to have that trademark already registered in order to show those three things. So the other criteria,
That is correct, and that goes to the question, did the registrant have legitimate rights to the name? If there's not a trademark registered for the name, it's going to be difficult for the complainant to make that argument that when the registrant registered the name, that someone else had a right to the name at that time.
Excellent. So, Johan, so not only filed but registered, that is correctly understood. Yes. With, like I said, very few exceptions, Australia being one of them. And Lisa, yes, this session is being recorded. We will have it available for you within 24 hours. And hopefully this has been good for you, and you can review it, and feel free to reach out and ask any questions of us, because they are sure to pop up later. And I do have another question. I'm not sure I understand it quite. Is there any recognition for well-known marks? Are you referring to marks as opposed to emoji, or I might need a little bit more information on that question, which are not registered? I'm not quite sure I understand that. Do you understand that?
I think they're referring to well-known trademarks. So if a trade name is well-known, but it's not a trademarked name, meaning it's not a trademark registration, whether that meets the requirement. I can't think off the top of my head, as far as UDRP goes, seen a case where the complainant did not have a trademark. Usually it's pretty clear that they have a trademark, they have rights. There are things, again, we're not attorneys, but there are common law rights, and I think in some jurisdictions and country codes out there may recognize that. As far as civil suits, there's a lot more factors in play when determining who has rights or not to a particular name.
Yeah, and now that you've explained it, I do see that there is kind of a trend of celebrities fighting for their name, just as we saw with Michael Jordan. And on the flip side, we're here to register domains. We often have some of these country code registries that make us prove that the person, the actual celebrity or high profile individual that's trying to register the name, is who they are. So there are plenty of those registries that are concerned about awarding these domain names to people who really do have legitimate interest in them. So it's not just one-sided. There are plenty of registries who they don't want to get involved if it's going to end up being litigation later. So they will request documentation with signed, maybe they want their autograph, I don't know, but signed information that proves that, sort of like the check mark in Twitter, I am who I am, and I really want this domain name for me. So hopefully that answered your question. Any other questions before we wrap up? Okay. Thank you. I'm glad I answered your question. And Otherwise, feel free to reach out to us, and thank you so much for staying with us here today on Wednesday, and hopefully this was informative to you. And again, thank you so much for visiting, and have a great day.